This will be the concluding blog about the recent case of Fyffe versus MBTA. There are a few more points I want to bring up so that we can understand what that case stands for and what lessons we should draw from that case. The court discusses speculation, and I've discussed this in past blogs about how an expert's opinion could be speculative, or how an argument made by an attorney may be speculative. And obviously what I'm saying applies to both sides. The defense cannot speculate as to what might or could happen, that sort of thing, any more than the plaintiff could. And the court was very offended that the plaintiff brought up the idea of quadriplegia, because the court stated there was no record of evidence to support such speculation. Once the court speaks in terms of speculation or the speculative nature or anything like that, you know that you are treading on very thin, actually, ice that will, through which you will fall. The court focuses on what is within the realm of reasonable inference from the medical evidence, and a jury cannot be invited to speculate about issues in the case. So that is a lesson that we should be mindful. We need hard evidence, reasonable projections to certain degrees of medical certainty, and our cases where we represent clients must be done with that in mind, because settlements, every bit as much as trials, will depend upon non-speculative evidence. I discussed in one of these blogs about the loss of earning capacity and how it is best established. And to be concise, you need a baseline as evidenced by tax returns from before the accident. Then you need to know, it's almost an arithmetic formula, how long, based upon the medical evidence, the client is out of work, and then you get a figure. There is also the notion of present value, and that figure that you get, projecting into the future, how long the client will be out and how much they will suffer as a result, has to be reduced to present value. But you don't necessarily need expert testimony and economist for that. You can put that evidence in, and the judge will instruct the jury accordingly. I discuss loss of earning capacity because it has to do with another, in the final aspect I'll talk about in this case, the notion of remittitor. That is a Latin term for taking away. The judge is considered whether there should be a remittitor, because did the jury's award of $1.2 million, was it too much for the plaintiff such that it should be reduced? The fact of the matter is, there's some comforting language in the decision for plaintiffs, for people suing, because the court said, although we are not prepared to say that the judge abused her discretion in denying remittitor, we take the view that because the amount awarded seems to lie in the upper range of what may be borne by the evidence, so on and so forth. In other words, the court considered that this figure, this award of $1.228 million, was in the acceptable range, though in the higher part. And that's a lesson that can only be beneficial to the plaintiffs, to the people suing. And I certainly will make that argument to my adversaries in the future in the course of negotiating cases. Thank you.